Good evening, Douglas County, and welcome to the 2018 Fall Debate hosted by the Business Council of Douglas County, the Record Courier, and the Carson Valley Chamber of Commerce. We're so glad that you're here this evening, and we have two different debates that we're going to produce tonight. We're going to have a Phase 1 debate, and that will be for Mrs. Jones and Mr. Levin. And then we're going to have the pro and con panels for Question 3, which is the most debated question in the history of Nevada and the most money spent on a ballot question. So we'll get to that later. We're pretty excited to hear about that. There's often a lot of information out there on particular candidates and about different items and questions, and you don't know necessarily what necessarily is true, what's false, what's fact. So we try to bring you each and every time since 2002 debates that bring you fact and they're relevant information that's going to be shared with you. And we pride ourselves in that. This is a nonpartisan evening. We welcome you to ask your questions through written, and there's pencils and papers over there, and you can turn them in over there, and we'll definitely get as many questions answered as we can. And the candidates will also be available during the break and after to also visit with you. This is airing live on recordcourier.com on demand, starting probably, I'm going to say, by next Monday. Could be a little bit sooner than that, but that's what I'm guessing. So we're excited for that, and we thank the Record Courier as well for being a sponsor and doing that. It's a lot of bandwidth. We know you guys are going to watch it a lot. So with that, I'd like to introduce the most important person of the evening, our moderator, Judge Tom Perkins. He also moderated our spring debate for the primary election and did a fabulous job for those of you that were here that attended. So with that, I'm going to turn over the evening to our moderator, Judge Perkins. Judge, take it away.
Thank you, Ray. Right now I probably ought to go around the room and introduce all the luminaries, and there are so many luminaries in this room that my eyes are sore. But I don't want to miss anybody. I do want to make a special recognition of a couple of judicial officers. So, Judge Garrison was the Justice of Peace when I started working here in 1983. Would you stand up, Judge? John Garrison. He was a great public servant, and I enjoyed working with him. And also Judge Gibbons from the Court of Appeals and former district judge of our district this year. So we have a timekeeper who will warn with the yellow card when you have 30 seconds left. The red card means your time is up, and please honor your time. Each candidate will be given up to 4 minutes for opening remarks. The order for opening remarks was drawn with the candidates earlier. Please wait for me to call on each candidate to proceed with your opening. After each candidate has given their opening remarks, we'll then move into the question and answer period. The first set of questions were drawn up by the Chamber, Record Courier, Business Council of Douglas County, and the moderator in a collaborative effort. So let's begin with the opening remarks, and I think Ms. Jones, you were drew the first slot for that, so go ahead with your 4-minute statement.
Can you hear me? Okay. So the first case I ever worked on was a grisly murder case. The victim had been dismembered, and as I handled the plaster wall that was cut from the crime scene, I learned a very important lesson. I learned that justice needs to be done, and it needs to be done well. My name is Cassandra Jones. I'm running for East Fork Justice of the Peace, and I am asking for your vote this fall. I was born and raised here in Northern Nevada, and when I went to law school, there was no law school here in Nevada, so I ended up going to Arizona State University of Law. I graduated in the top 10% of my class, and a mere 8 days after finishing school, my husband and I packed up the car and we moved home. My husband and I are about to celebrate our 20th anniversary, and we chose to invest in Douglas County and to raise our children here. My first law job was here at the law firm of Brook and Shaw. While I was there, I did criminal and civil litigation here in Douglas County. From there, I went to the district court, where I worked as the staff attorney for Judge Gibbons for over 5 years. While there, I handled felony level cases, high conflict family law, and civil litigation on a weekly basis. In addition, I helped to rewrite the local court rules, which are still in use today, and I helped to establish the Special Advocates for the Elderly program. That's a program where volunteers can give voice to adults under guardianship. It is the gold standard for the state and was recently adopted by the legislature as a recommendation for every court in our state. About 8 years ago, I went out on my own. I own Heritage Law Group. We are a small business. There's generally 2 lawyers there. And when I started practicing civilly, I did high conflict family law. And I still do high conflict family law. Most people don't know that because it's not what I advertise. I'm honored to be known for my work advocating for disabled and elderly adults, but it is only a portion of my overall experience. In the last 8 years, I've also become a court-certified arbitrator and a mediator, and the Douglas County Commissioners have agreed that I am qualified to do this job because 3 years ago they appointed me as Justice of the Peace Pro Tem. I believe that justice needs to be done, and it needs to be done right. We need justice in order to have a safe and vibrant community. And that means that the law needs to be equally and fairly applied to every person in the courtroom. And I am committed to ensuring that, as the only independent candidate here, that if someone comes to my courtroom, they will be treated fairly and equally. Additionally, criminal sentences need to be consistently enforced, and victims need to be empowered to seek and receive the protection to which they are entitled. I believe that that is what it means to have justice in our community, and justice is key to having a safe and vibrant community. And so I am asking for your vote. Voting starts on Saturday, but anytime until November 6th. Thank you.
Mr. Levin?
Hi, I'm Eric Levin, and I'm running for Justice of the Peace because I want to keep you safe. I want to bring my many years of experience to bear to allow litigants to have their issues fairly heard in court and to hold offenders accountable. My background, my broad background, my extensive experience as a prosecutor, and my conservative judicial values make me the best candidate for Justice of the Peace. As a Douglas County Deputy District Attorney, I've practiced in the courts of Douglas County for the last 10 years. I've prosecuted thousands of cases, from minor traffic citations to murder. And I'm the only candidate to regularly litigate in the justice courts of Douglas County. Previously, I was a Deputy Attorney General. I prosecuted crimes committed by state prisoners. I prosecuted crimes committed by our state officials while on the job. And I defended the convictions of Nevada's worst offenders in the federal court system. I also served 6 years in the civil division of the Nye County District Attorney's Office, where I provided legal advice and services to almost every elected official and every department head in the county. Prior to beginning my law career, I spent 13 years in the private industry in the aerospace field. I managed high-valued contracts that were vital to our national interests. Contracts for NASA, the Department of Defense, and the country's intelligence agencies. And while I was doing all that, I put myself through law school at Loyola Law School. My broad experience provides me with the tools to fairly and effectively manage the East Fork Justice Court. I've made the arguments for offender accountability in countless contested hearings in an effort to ensure the community's safety. Experience matters, and I'm the candidate with the experience appearing in and litigating in justice court. And while I've spent the last 10 years here in Douglas County in the courts here, prior to that, I was litigating in other courts, and I've litigated in 15 of Nevada's justice courts. And during this time, not once have I seen my opponent litigate any case in justice court. I'm aware she served as a law clerk and handled a variety of cases. But handling cases as a law clerk is not litigating. It's reviewing files that other attorneys have litigated. and I'm aware that my opponent served 1 day as a temporary judge in the Tahoe Justice Court. But on that day, not one sentencing hearing that she had was contested. Every sentence that was handed down in a criminal case was pursuant to a plea agreement without deviation. She didn't have to make those hard decisions that I've been making for the last 10 years when there's a disagreement about what an outcome should be. Experience matters. So tonight, I'm challenging my opponent to tell this community how many criminal cases has she litigated in justice court, prosecuted or defended? How many civil cases has she tried in justice court? My record is available for review. It's available for review in the courts, and it's been summarized in the Record Courier. Tell us which courts you've tried cases in so that people can review your record. I am endorsed by the sheriff-elect, and the Douglas County Sheriff's Protective Association. And I believe it's partly because of my 13 verifiable years as a prosecutor holding people accountable that I earned those endorsements. And with your vote on November 6th, I look forward to continuing to keep this community safe. Thank you very much.
Hey, excuse me. The questions are going to go in reverse order. So even though we just heard from Mr. Levin, we're going to hear from him again, and then what I'll do is I'll ask a question. Let me see. This is what happens if you don't follow your script. Each candidate will be asked a question in a round-robin format. The first candidate will have 2 minutes to answer. The opponent will then have 2 minutes to respond. The first candidate may request to rebut the response, and the moderator may accept or decline a rebuttal request. If granted a rebuttal, you will be granted 30 seconds to speak. The moderator will then reverse the order for the next question. The moderator may choose to have follow-up questions or move on to a new question for the next candidate. We'll begin in reverse order of the opening remarks. So the first question is for Mr. Levin, and this question gives you both a chance to follow up on your opening remarks. This question is, Mr. Levin, how has your experience prepared you for the role of Justice of Peace?
Well, the majority of cases in the East Fork Justice Court are criminal cases, and I've been a criminal prosecutor for over 10 years. I've handled just about every kind of case there is, as I stated, from traffic citations to murder. I've had jury trials, and I've had numerous bench trials on criminal matters. And though not as extensive, I've also litigated civil matters in justice court, small claims and contracts cases. I've had the opportunity when I'm in court waiting for my cases to be heard to observe the civil dealings in justice court. I also, with respect to the civil aspect of protective orders which are issued out of the justice court, I've been involved in those, in both helping people obtain them and prosecuting people for violating them. So I've got quite an extensive experience in the justice courts, and doing all that has helped prepare me for the role. I've been in there a lot. I work closely with the court staff to get matters heard, to get documents in front of the judge for his review. So I know how the justice court works. I've seen how they operate. I'm very familiar with it. And I think I'll do a very good job as the next Justice of the Peace. Thank you.
And Ms. Jones, how has your experience prepared you for the role of Justice of the Peace?
I'm uniquely qualified to serve as Justice of the Peace because of my experience in both criminal and civil litigation on both sides of the bench. The East Fork Justice Court handles a broad range of cases. Only 60% are criminal in nature, and that does include misdemeanors and the early hearings and felonies. But 40% of the caseload is civil in nature. That's anything $15,000 or less, and that includes protection orders, evictions, and small claims. I do have well over 15 years in criminal and civil litigation. I began my career handling criminal litigation in the local justice courts. as an associate attorney at the law firm of Brook and Shaw. During that time, I also handled civil litigation. In the last 8 years, I have built my firm on a high conflict family law model. And the preparation of a case in civil court is identical to that of criminal court. The evidence code is the same. Preparing your witnesses is the same. Questioning witnesses is the same. And I have, just last month, won the equivalent of a civil death penalty case after 2 years of litigation. My opponent says, check his record out in the Record Courier. I encourage you to do that. Because if you look back at the last 2 trials that he's won, he has lost the equivalent of that same murder case. I have experience handling every type of case that comes in front of the Justice of the Peace. I have had this experience as a judicial officer, as an arbitrator, a mediator, and yes, as Justice of the Peace pro tem. And on that day, I handled every type of case that comes in front of that judge, and I did not sentence them on uncontested pleas. In fact, I remember specifically sentencing someone to a higher level on DUI because of aggravating factors. I have the strong background and experience necessary to do this job and to hold people accountable. Thank you.
No rebuttal. Ms. Jones, this question will begin with you. What personal qualities do you bring to the position? So we're asking about your personal qualities.
Right. I'm looking for a page that I had. There we go. So the question is, what are the personal qualities do I bring to this seat? And that's an important question because the statute says that you only need to be a qualified elector with a high school diploma to hold this position. And so the legislature recognizes that our law degree is not the most important quality in your Justice of the Peace. I think the most important qualities are that your Justice of the Peace show excellence, show wisdom and discernment, and show a heart to serve this community. And I believe that my 15 years of experience in public and private practice and in volunteering to serve this community shows that I have all 3 of those qualities. I am the only candidate to have volunteered my time outside of work to serve this community. On the Austin's House Board, I have served for over 6 years. I'm currently on the Town Board of Gardnerville. And I have been named as a pro bono advocate for 13 consecutive years through local legal service providers. I have been recognized for my excellence and my service to this community by the people that matter, you. I have earned the Best of Carson Valley 3 years in a row. And the Business Council, who's throwing tonight's event, has named me the best professional service provider in the county. Additionally, my peers have appointed me to the Judicial Ethics Commission for 2 terms in a row. I am honored to have been endorsed by my clients, by my peers, and by community leaders. And I believe that this reflects that I have the excellence in my work product, that I have the wisdom and the discernment, as well as the heart to serve as your next Justice of the Peace. Thank you.
Okay, Mr. Levin, what personal qualities do you bring to the position?
Well, I think 2 personal qualities that are extremely important that I bring. First is demeanor. I think a judge, as well as a prosecutor, has to have a very good and a calm demeanor. You can't lose your patience. You have to be a patient person, which I have demonstrated for the entire 10 years that I've been practicing here, both in court, when things get rough, when pressure's on, when people are calling you names and all that, you have to keep your cool. And I've done that here for the past 10 years. And then the other personal quality that's extremely important for a prosecutor or for a judge or for a defense attorney is you have to have some compassion. And I've shown compassion for some of the people that I've prosecuted that just need some help, as well as my victims. And I think I've got a reputation in this throughout the court system for keeping my victims informed, helping them come to court to get their feelings heard and get justice for themselves. I stay in touch with them even after the cases are concluded. I've got One or more of them are here tonight watching this debate, and I appreciate that very much. They've written me letters thanking me for what I've done for them, and that's important to keep them involved, to understand what the process does to them, as well as to everybody else involved. And I think that I have demonstrated that in all the courts in this county for the last 10 years.
Okay, the next question, again, we're going to go starting with one and finishing with the other. So in this one, we'll begin with Mr. Levin. What are your plans for managing the caseload and bringing in a second justice of peace in the East Fork Township?
Thank you, and I've spoken about this before. I have zero plans. I can commit to you that I will not bring in a second, or I will not ask for a second justice of the peace. The final decision isn't up to me, but I will certify that it's not required. There's a fair-sized caseload in the East Fork Justice Court, but it's something that I can handle. I think my judicial philosophy will be fine with it. We don't need a second justice of the peace. We don't need additional staff. I've told you I've got conservative judicial philosophy. I'm also a fiscal conservative, and I don't want to spend your money any more than I want to spend mine, and I don't want to spend mine on it. It's a busy court, but it's not the busiest court in the state. There's many judges in Clark County and Washoe County with higher caseloads. So there's things that can be done to manage the caseload in terms of scheduling, in terms of my judicial philosophy, which is to hold offenders accountable, which means that there'll be fewer chances at violations, and that means there's going to be fewer appearances in court. So my belief is that we've got many years to go before we need to add a second judge or another courtroom or additional staff, and that's my commitment to you.
Ms. Jones, what are your plans for managing the caseload and bringing in a second justice of peace in the East Fork Township?
I think this is an area where Mr. Levin and I are on the same page. The East Fork Justice Court is overpopulation and by statute can have a second judge. But you don't get that second judge if the current Justice of the Peace writes a letter to the legislature saying that we do not need that judge. And I am committed to also writing that letter. But I do not think that we should be comparing ourselves to Las Vegas or Reno. We have the busiest rural court in the state of Nevada. And while we are the busiest rural court, we are actually the lowest caseload in 10 years. And so instead, we should be focusing our resources on refining what we have and being more efficient with the limited fiscal resources that we have. As a small business owner, I am the only candidate with experience managing a busy caseload, a limited budget, and a staff, and I will use those skills to assist in refining the efficiency of the existing justice court. And I'm in favor of using technology to make the court more efficient. This would include things like using technology to prevent us having to move defendants, making our officers safer, but also using technology to allow a victim to appear by video conferencing. The Supreme Court has stated recently that a victim you can do that. Someone can appear by video, and it meets the requirements of the defendant's right to confront their accuser. And so we can use technology to give victims a voice while also protecting them from having to be in the same space as their perpetrator. I believe that my experience as a small business owner and handling a heavy caseload and staff is directly related to managing this court, and I will bring those skills to serve you.
Okay, this one will begin with Ms. Jones. And folks, I'm gonna talk just for a minute so everyone understands what this is about. There's a movement and trend among the states, ranging from Kentucky and Arizona to California. So states that you would traditionally regard as being conservative, as well as states that you might consider to be liberal, to eliminate monetary bail, either in the form of cash bail or bail bonds. in criminal cases. In this, decisions on pretrial release, that's before trial, before a case has been decided, would be made on the basis of a validated pretrial risk assessment tool. What that means is there's a set of questions with scores that are proven around the country about whether people come back to court or get in trouble while they're out, pending their, before their trial. And the question beginning with Ms. Jones, what is your position on this movement and trend?
I believe that the Justice Court plays a vital, a critical role in maintaining the safety of our community. It is the court where all criminals first come, and therefore the tone that the Justice Court sets is key to whether that criminal or that defendant reoffends. And in my courtroom, the tone will be unmistakable. Bail and sentencing conditions will be clear, and they will be consistently enforced. The trend to eliminate cash or bond bail actually is not permitted by Nevada statute. Many of the crimes have minimum standards for bail, and bail is designed to do three things. It is designed to keep the community safe, to protect the victim, and ensure that the defendant returns for the next court hearing. The minimum standards, and while there is a trend towards eliminating cash or bond bail, the minimum standards are just that. They are minimums, and we are not Las Vegas, and we are not Reno. We do not need to be letting people out onto the streets with no accountability. The minimums, however, can be above that, and the Justice of the Peace can set something higher than that if they meet with the defendant in the courtroom before finalizing those conditions. Those conditions can include things like drug and alcohol testing, an appropriate cash or bond amount, stay-away orders from victims or even from locations. I believe that the Justice of the Peace has an obligation to review each case individually to ensure that the appropriate bail conditions are set to protect our community and to protect the victim. And I am committed to firmly and consistently enforcing those conditions as a reflection of the community values that we have here and that I share with you. Thank you.
Hey, again, Mr. Levin, your position on the movement and trend to make decisions on pretrial release on the basis of a risk assessment tool and the elimination of cash bail or bail bonds in criminal cases.
Thank you. And first, I'd just like to thank the comment about allowing victims to testify via audio video. That's exactly what I did 2 weeks ago, as I had a woman sentenced on a DUI causing death and substantial bodily harm. The victims were out of town, and I arranged for them to do just that. It's already being done. With respect to the trend to eliminate cash bail, I am adamantly opposed to that. Bail is what's needed to keep the community safe from offenders. And there's some offenders don't need it. Thank you. Some offenders do not require a cash bail or any bail. They can be released depending on the crime and their background without a threat to the community. But many do require it because they need to have a bail, they need to have conditions on them. Those minimums that you just heard about, those are initial minimums. They can still be altered once the defendant comes and appears before the judge. And I'm committed that when I look at a case, if I see somebody that presents a threat to the community, a threat to an individual, we're not going to just release them. Bail is an important part of that. The conditions, as you've heard, are an important part of that. Those are the things that I've been arguing in front of the judges in this county for the last 10 years. I make liberal use of my arguments for increasing bail, keeping bail where it is, for imposing conditions to the great tools that we have through our Department of Alternative Sentencing. There's the use of alcohol monitors, the use of GPS monitors to keep somebody out of a particular area, as well as random drug and alcohol testing. And I'm going to continue to do that as your next Justice of the Peace, just as I have been doing as a prosecutor for the last 10 years.
All right, I think Next one would begin with you, Mr. Levin, and then close with Ms. Jones. What is your opinion of the existing justice and law enforcement facility in terms of the space needs for the courts, the district attorney, and the sheriff, as well as the many other support agencies housed in the facility? And before you start answering, there's a second part to the question, which is how do you see your role in planning and advocating for additional facilities? Go ahead first, Mr. Levin.
Well, I work in the district attorney's office, and I'm familiar with some of the space needs there, as well as the court. The facility houses a number of entities, and they're all interconnected. And there is a space issue. I know there's a committee, and things are being done now. As a justice of the peace, I'll participate in that and provide my input. There are needs. Until they can be met, though, I'm confident that I can continue to run the justice court and get the cases processed in an orderly and safe manner. But there are things that need to be done. As I walk through the facility, and I've been in all the offices, I can see crowding in the sheriff's office, particularly in the investigations division, crowding in the DA's office, particularly in the civil division. I think there's a move right now to try to find some additional space for them. And the other thing I need to do and would like to do as justice of the peace, and I don't think it would require a great deal of expenditures, is improve the facilities for not only the justice court, but the 3 courts in that building. Right now, when cases are scheduled, when court is scheduled, there's sometimes a shortage of seating for participants in the court system, particularly if 2 of the courts have cases going on at the same time. We don't have the facilities that I'd like to see to make sure that when victims come into the courthouse, they have a seating area where they don't have to be sitting right next to their assailants or the defendants who have victimized them. And I think that's an important part, and I see my role as advocating for some facilities to keep that separation, and that's what I'd like to do as justice of the peace.
I think one of the most disturbing things that happened to me was when I shared a story where I stood between my client, the victim, and her perpetrator. And my mother-in-law, who worked in the same building 30 years ago as an investigator for Douglas County Sheriff's Office, could tell me the same story about how she stood between a rape victim and that person's perpetrator. The building is ill-designed for its use, and it does need to be updated. There are areas that are overcrowded and out of date. And so the question isn't whether we need to update the building, it's how do we get it done? What is the funding source? I believe that the 5 elected officials in that building need to lock arms hand in hand. That didn't work out, but they need to lock arms and they need to go to the commissioners and they need to advocate for what justice requires. Because each and every elected official in that building owes a duty to you to ensure that justice is fairly and equally administered and safely administered in our county. I have already been advocating for this. You can go back and see the public comment. I have provided my stories to the commissioners about how it is an inefficiently designed building and it needs to be updated. I have already begun talking to different people about how would we find the resources necessary to remodel the building, either in part or in doing a complete expansion. As the only candidate who has served on a board in this community, I know what it's like to have to talk to a board and try and find a funding source, and what it means when you're dealing with a board who is considering whether or not taxes are necessary. I am not in favor of raising our taxes to pay for this, but we do need to identify a funding source in order to remodel the building, and it should be one of the highest priorities of the Sheriff's Department and the courts. Thank you.
Okay, this next question is from the audience, beginning with Ms. Jones. If elected, how will you handle conflicts of interest?
I believe in the firm, fair, and independent administration of justice. And that includes the constitutional guarantee that the judiciary and the executive branch are treated separately from each other. In our county, the executive branch includes the DA's office and the sheriff's office. I am the only candidate who has maintained independence. And for that reason, when someone comes before me, there will be no question that they will be fairly and equally treated in my courtroom. I have intentionally not sought endorsements in this race because I don't want there to be any question that when a defendant appears in front of me, that they are being treated fairly. I have no conflict of interest with the district attorney's office, and I will have no conflict of interest with the sheriff's office. I might have a conflict of interest based on my private practice, in which case I'll have a database of my clients that we'll double check against, and if I need to withdraw, I can do that. Because no one should question whether they're getting fair and equal treatment in my courtroom. Thank you.
The issue whether or not there's a conflict of interest is a simple one. If there's a conflict of interest, you must recuse yourself from a case, and that's what I will do. This notion that my opponent is independent and I am not is nonsense. I am independent. We both spoke to the Sheriff's Protective Association, and what she said to them is what they told me is that they could endorse her, they could endorse both of us, or they can endorse neither of us. I'm certain that every deputy in that room took that as a request for an endorsement. And in fact, if getting an endorsement creates some sort of conflict of interest, then my opponent has already conflicted herself out of 25% of the criminal caseload in the East Fork Justice Court by the endorsements that she's put in the newspaper from the local defense bar. It doesn't create a conflict of interest. It doesn't affect your independence because somebody endorses you. It's an expression of support based on however somebody feels. In my case, I believe it's based on my experience. So conflicts of interest are easily handled, and they're simple. You just recuse yourself from the case, and that's what I will do.
I'm going to follow that up. Ms. Jones, are you suggesting that somebody who starts out as a prosecutor or public defender would thereafter be disqualified from serving as a judge? I just need to know if you think that that creates an inherent conflict that would disqualify someone from acting.
I don't think it disqualifies someone from acting, but the way you run your campaign is a reflection of your discernment. And so you have a choice in running your campaign whether or not to present yourself as someone who will fairly and equally apply the law, and then provide assurances to the constituency, to the voters, that when they appear in front of you, that they will be treated fairly. And so there is a question, you have, as a judicial, the issue of judicial demeanor. Are you staying above the fray so that, that any defendant coming in front of you knows that they are being treated fairly and equally? And that is what I have attempted to do. And I do disagree with the representation that Mr. Levin stated.
All right. Mr. Levin, I'm going to ask you a follow-up question, too. I think you've challenged Ms. Jones on the basis of experience in justice court, and she's challenged you on the basis of her activity in the community outside the courthouse. And so I'd like to have you follow up and explain how you can function as a perceived leader in the community with perhaps a history of professional work inside the courthouse. What have you done outside the courthouse to connect with the people out here?
I've made connections throughout the community in a variety of means, through friendships, through going to events, through participating in fundraisers. I am on the board of the partnership Douglas County. My opponent has done a lot of things in the community, and she should be commended for it. But that doesn't give her the background to sit as East Fork Justice of the Peace, where you are deciding when and whether or not a police officer can go into somebody's home at night, or whether somebody should be released on bail. Those are the things that my experience working have done. some of the things that she's done, I'm not allowed to do because of my position as a prosecutor. I cannot provide free legal services to the community. I cannot sit as a judge pro tem. But by virtue of the people that have shown up to see me today, by the events that I've gone to, supporting the various fundraisers, Minden Fortnightly, the Intero Chili Cook-Off for Kids and Horses the other day, the Food Closet. I've participated in a lot of those activities and gotten to know a lot of really terrific people in the community.
Ms. Jones, do you believe it's important for the future Justice of Peace to have tried criminal cases in the East Fork Justice Court? And why or why not?
I don't think it's necessary to have tried a case in the East Fork Justice Court. There are courts all over northern Nevada, and the rules of evidence and procedure are the same in a criminal case or a civil case. I have appeared in Washoe County, Carson City, Lyon County, Churchill, and Douglas, and I've also appeared in several counties in California as I'm active in both states. I have litigated cases and tried cases in several counties and in northern Nevada as well as in California. The issue of whether I appear regularly in justice court or not. I'm not a prosecutor, and so I can't prosecute a case, but I have prosecuted claims in the sense that I have litigated them, and I have taken them all the way through trial and appeal. And I have represented victims and traumatized families for years, and those skills are directly related to what happens in a misdemeanor court. And so you cannot ignore the experience in the district court and say that only the East Fork applies. As for the idea of serving in the community as a pro bono attorney.
Wait a minute. I was just asking you about the experience one. I'll follow up with something else for you there. And and I'll start with you on this one, Ms. Jones. I'm going to give you how will your court be different from other courts prior? And I'm not asking you to rag on me, but you may. But I think it would be more appropriate for you to talk about improvements that you would like to make, and I'm giving you a chance to do that.
So I think when it comes to the East Fork Justice Court, it's not so much that it should be different. It's that when we talk about what it means to have justice in our community, to have the only misdemeanor judge ruling on cases, we need a judge who will fairly and equally apply the law, who will consistently set bail standards, who will consistently enforce bail and criminal sentences. And that is what I am committed to doing. In addition to that, I am committed to embracing the administrative needs of the busiest rural court in northern Nevada. Because I believe that the Justice of the Peace owes a responsibility to the people in this community to ensure that the People's Court is the People's Court, that it is accessible and usable. And so we've talked about some of that might include changes or remodels to the Justice Court, but that also includes ensuring that in the courtroom, the law, the process, and the judgment is clearly articulated and clearly followed. Because most people appearing in that court have no experience in court before. It's the worst day of their life, and many of them don't have attorneys. I am the only candidate with experience in private practice. I'm the only candidate who's ever been retained by an individual. And my experience as a private practice attorney in small business is directly related to sitting on the bench as Justice of the Peace and ensuring that the law is clearly explained, that the process is clearly explained, and that the judgment is clearly articulated so that every person in the courtroom understands and accesses justice for themselves. Thank you.
Okay, Mr. Levin, the same question to you. How will your court be different, or what improvements would you make to the court?
Well, of course I appreciate you, but you know from my arguments that I do have a different philosophy in a lot of respects. And one of them is with bail violations and violations of suspended sentences. Many defendants come in and they need a second chance. And they deserve it and they'll get second chances. But I don't believe in repeated chances When you subject yourself to the jurisdiction of the court by committing a crime, you don't get the same chances that everybody else in society might have. You've given some of that up, and you need to actually step it up at that point, and I intend to hold people accountable. When they're given bail conditions, they're going to be expected to abide by them, and if they don't, they're going to go back in jail, and we're going to talk about raising the bail because they've shown that they can't abide by the conditions which are meant to keep the community safe when they violate. And the same thing with the suspended sentences. I don't know what it means to enforce when my opponent says, I'm going to enforce my sentences. Of course a judge is going to do that. But how you deal with that sentence and how you deal with the violations is what makes the difference in the safety of the community. And that's what I'm going to do, is hold people accountable in that respect.
May I have my 30-second rebuttal?
One of the, there's other little changes I'd like to make in terms of scheduling that I think might help with the court efficiency. But the big thing is the things that will provide for the community's safety. Thank you.
Okay, we're going to close with final remarks from the candidates. Each candidate will have 4 minutes for their final comments, and it'll be in reverse order from the previous round, and also from the opening statements. So, Mr. Levin, your final remarks first, and then Ms. Jones, your final remarks at the end. So you have 4 minutes if you choose to make final remarks. And before you start that, I want to tell both of you and also the people out here, it takes a tremendous amount of courage to apply for public office and to express a desire to serve the public. And I want to compliment both of you on the courage and the energy and your willingness to serve. And I tell you personally and professionally, I can't thank you enough for putting yourselves out there and providing the community with this choice. So Mr. Levin, you'll go first with your closing remarks.
A few weeks ago, the Douglas County Sheriff's Protective Association held a meeting for the purpose of determining which, if any, candidate they would endorse for Justice of the Peace. Both my opponent and I went and spoke to them. I'm told that my opponent suggested to them that they could endorse her, they could endorse both candidates, or they could endorse neither candidate. They chose a fourth option, and they endorsed me. And to me, it's sad now that my opponent criticizes me for that endorsement, saying that it somehow makes me not independent because of a connection between the executive branch and the judicial branch. Well, first of all, the association is a private association. It's not part of the executive branch. And my opponent also claimed that she now claims that she never sought the endorsement, despite what I'm told she said at that meeting. And I was not there, I will tell you that. But I think that's sad for 3 reasons. And the first is that our founding fathers enshrined in the Constitution the concept that the head of the executive branch, the President of the United States, endorses our federal judges. He nominates the Supreme Court justices and the justices of any lower courts that the Congress creates. And we recently had a confirmation hearing for Judge Kavanaugh where he was confirmed. And most of the cases that he'll hear as a Supreme Court justice involve the United States, the several states, and the political subdivisions. And despite all the allegations that were hurled against Judge Kavanaugh, one that I don't recall hearing is that he could not be fairly and independently hear those cases, despite the fact that he was nominated by the President, endorsed by 31 governors, and 26 attorneys general, the chief law enforcement officers of their respective states. When we started this debate off, I told you that I wanted to be Justice of the Peace to keep you safe. Pursuant to statute, the Justice of the Peace is the conservator of peace in the township. Of course, you would want to know who your law enforcement endorses to help you make an informed decision about who's going to best serve that function. And finally, if my opponent truly believed that an endorsement somehow makes you not independent, as I stated, then with the endorsements she's received from the local defense attorneys, she's already had to conflict herself out of 25% of the criminal caseload in the East Fork Justice Court. I don't believe that an endorsement makes you independent. I don't believe she's conflicted out, but that would be if you believe that. So what my opponent criticizes, I embrace. I've been endorsed by Sheriff Ron Perini. I've been endorsed by Sheriff-elect Dan Coverly. I've been endorsed by his designated Under-Sheriff Ron Elgus. I've been endorsed by the Douglas County Sheriff's Protective Association. I'm very proud to have earned those endorsements, and I'll be very proud to earn your vote on November 6th. Thank you so much.
I'm not going to spend 4 minutes here talking about why other people should have supported me. I'm going to talk about why I love Douglas County and why you should vote for me. I want to thank each and every one of you for coming here tonight to learn more about the candidates and about our experience and background. No one wants a safer Douglas County than I do. And I believe that my broad background and experience in criminal and civil law and the unique experience that I have from both sides of the bench as a judicial officer and as a small business owner who is invested in this community make me uniquely qualified to serve as your next Justice of the Peace. I love this community. I grew up here. I chose to be here. And I have chosen to raise my children here, and I have chosen to invest in this community and build my business here. I have served Douglas County for over 15 years in my paid work as a private attorney and a public attorney, but also for 15 years of community service. The rules of professional conduct do allow government attorneys to do pro bono work. Using that rule, I did pro bono work even when I was working at the county. And I have done uninterrupted pro bono work for over 13 years. So it is not accurate to state that my opponent could not be doing the same service to this community that I have been doing for over 13 years. I have handled every type of case that comes in front of the Justice of the Peace. I've done so as an attorney, but also, I've done so as a Justice of the Peace, pro tem, sitting on the bench. Additionally, my experience as a civil practice attorney is directly relatable to what occurs in justice court in ensuring that the law is fairly and equally applied and that justice is efficiently administered. Second, I am a small business owner, and I am the only candidate with the experience of what it means to manage a busy caseload, a staff, and limited resources. I am fiscally conservative, and you can see that in the way that I have run my business and in the way I've handled the resources available at the Town Board of Gardnerville. And I am committed to continue efficiently using the resources at the Justice Court. What does it mean to fairly and equally apply the law? It means that when someone walks in the courtroom, they're not worried about whether you are in favor of the other side. And I am committed to ensuring that the law is fairly and equally applied to every person in my courtroom. What does it mean to consistently enforce sentences? I think this is an area that Mr. Levin and I don't disagree on. It means you get a chance, and if you blow that chance, it is my solemn responsibility to ensure that you are no longer a danger to the public, and that will include putting you in jail if necessary. And what does it mean to ensure that a victim can seek and receive the protection they are entitled to? That means that we have to make sure that they have access to justice, forms online, forms available at the counter, doing simple things like adding a computer kiosk to print the self-help forms. But it also means being accessible in court, in having a demeanor that says you can talk to the judge, because this is the busiest court in rural Nevada. And my experience in small business and in serving the community make me uniquely qualified to handle the caseload and the people coming in to the busiest court in rural northern Nevada. We need justice in our community to maintain its safety and to maintain its vibrancy and economic development. And I am committed to ensuring that the Justice Court provides that justice so that our community continues to be safe and vibrant. My name is Cassandra Jones, and I am asking to serve as your next Justice of the Peace. Please vote for me. Voting starts Saturday. If you have any questions, you don't hesitate to email me, to call me, or I will be at the table after the events tonight. Thank you.
Okay, we're going to take a 10-minute break, and then we'll begin the debate on question 3. And don't give up your seat, because I think there's thousands of people waiting to come in for the session.
Would you please give a large round of applause to these two candidates who very clearly worked hard and prepared for this evening and for the potential of serving in that position. Thank you to you both. Thank you. We'll see you in 10 minutes. Good evening and welcome back to part 2 of the final 2018 Town Hall debate held right here at the Douglas County Community and Senior Center in Gardnerville. In this last section, we're going to throw the baton back to Judge Perkins, and we are going to hear the pro and the con arguments on question 3, the most hotly contested ballot question on the ballot this year. With that, Judge Perkins, take it away.
Thank you. So it's possible that you may have seen an advertisement about question 3 on television. This is the Energy Choice Initiative, and I'm going to leave it to the proponents and opponents to explain it in more depth. But this is the second vote we've had on it. It passed in 2016, and in Nevada ballot initiatives that come from the public must pass twice to be put into place. And therefore, this election is the decisive referendum on this initiative. And we have both groups here tonight, and I'm going to just introduce them. Representing yes, and that's pro. That doesn't mean they're the professionals. That means they're in favor of it. This doesn't mean they're the convicts. They're against it. Okay, so this is Ryan Cherry and Josh Weber for yes. I'm representing no on 3 are Michael Roberson and Madonna Long. Now, as in the last debate, we're going to have opening remarks, and the proponents will begin and have 4 minutes, and then the opponents will have the floor for 4 minutes. And I'm going to ask you, both groups, to do something. I guess I don't mean to spring any surprises on you, but I think I prefer, and the audience would prefer, for one person from each group to speak on each question or issue, rather than splitting your time up. So if one of you will give the opening statement, and then maybe if the other one wants to field a question or whatever, but I don't think we're going to have both representatives speaking on each point. So let's begin. Mr. Cherry or Mr. Weber, do you want to make an opening statement? You're welcome to do so.
Hey, thanks for being here tonight, everybody. So I'm going to briefly go over what is question 3 and why we support it from the yes on 3 stand. So question 3 is a constitutional amendment that does 3 major things. It ends NB Energy, or the utilities, a monopoly on electricity generation. It guarantees Nevadans across all rate classes a certain set of rights, and it establishes the rules and regulations governing a competitive market are put in place by July 1st, 2023. That doesn't mean we have to transition the entire competitive market by July 1st, 2023. You just need to know what those rules are that are going to be guiding it, so you can make an informed decision on how you want to procure your power with the rights we guarantee you underneath the constitutional amendment. So with the elimination of NB Energy's monopoly on electricity generation, we're not ending them entirely. We are allowing them to compete. We're allowing people to compete with them in the market. So a retail electric provider could come in, provide an option for you to leave NB Energy, and that would fulfill that requirement of the constitutional amendment, eliminating the monopoly, so you have a choice. When it comes to the rights that we guarantee underneath this, we guarantee you the right to self-generation. We guarantee you the right to enter into competitive markets, and we also guarantee you the right to join with others, whether it's in your community, whether it's across rate classes, so you can join with industrial customers, small business, residential folks, which you can't do now, to procure your power directly from the wholesale market. So you don't have that retail markup through the competitive market. And so why do we support question 3 with that being said? We support question 3 because we believe it will reduce your costs. And why we believe that is because since 2014, and I handed out a flyer, I'll make sure for the folks who are online, we have digital copies available for you guys so we can find a way to make it available to you. But since 2014, if you look on this graph at the bottom of the page, you can see that NV Energy has over-earned 346, and for those of you in the room, they are back on that back table if you didn't get one when you came in, has over-earned $347 million on all of us as ratepayers in the state of Nevada underneath their service territory. So the 85% of the customers that are serviced by NV Energy have overpaid them $347 million, past, above and beyond what the PU set as their regulated rate. We believe that by moving into competitive market, you will also be able to reduce that, because in competitive markets, the average rates are about 2 to 4% in those returns for their investment. Right now, the Public Utilities Commission puts a ceiling on NV Energy's guaranteed returns of 9.4%. So what we're saying here is we believe the costs are going to go down because NV Energy, one, retail electric providers in competitive markets won't be guaranteed a set rate of return. They're going to be working with free market principles to set their rates of returns. Those average much lower than they currently are, and there won't be someone over-earning in the marketplace. We believe it's going to produce, and the other thing we believe that's going to drive down costs is that if you look at states that have transitioned from monopoly markets to competitive markets and compare those markets before and after, competitive markets reduced their real price of the offerings that they were giving customers by 14%. In monopoly states, over the same period of time, they reduced those rates, or they increased their rates by 5%. So competitive markets naturally bring those down. We believe that's going to produce more jobs. A study that was done by RCG Economics in Las Vegas in conjunction with UNLV saw that the Governor's Office of Economic Development's projections for clean energy sector jobs grew to 34,000 new jobs, both direct, indirect, supply chain, all encompassing in the decade of 2023 to 2033. Without question 3's passage, those projections are about 5,000 jobs. So there's a major growth opportunity. We also believe that it will result in more renewable energy development. So,
Okay, thank you. Then Mr. Roberson or Ms. Long, go ahead with your opening statement.
Good evening, everybody. Thank you so much for being here. My name is Mike Robertson, and I represent the Coalition to Defeat Question 3. Before I get into our arguments, I just want to talk a little bit about who I represent. You're going to hear a lot about NV Energy from the Yes on 3 team here tonight, but there's a whole hell of a lot of people who've come out against this. If you look at the week card that I handed out, you'll see a partial list of some of the folks who've endorsed us. If you go to our website at noon3.com, you can see other people who've joined since. The Reno Sparks Chamber of Commerce and the Henderson Chamber of Commerce are a couple of the more prominent ones. But as you look at the facts on this and you hear a lot of different things, and you're going to hear a lot of conflicting information from our campaign and the Yes campaign, I want you to think about the folks on here, and if there's somebody that you trust in this group or something that speaks to you, I'd encourage you to look at what they say on it. Also like to point out, anytime you get the Sierra Club and the Mining Association together, you get big business and labor unions together, all these diverse groups that couldn't agree that the grass is green and the sky is blue to oppose something, it says a lot. So why do we oppose question 3? If you look at the language of it, it talks a lot about choice, it talks about competition. I think it says something maybe about apple pie in there, but it speaks to a lot of values that just resonate with all of us as Americans. I got to tell you, if I had the opportunity to write this ballot question, I would have worded it much differently. And I think the relevant question we all need to ask ourselves is, do we as Nevadans want to invest $4 billion to dismantle one of the most reliable and affordable utility systems in the country and replace it with a deregulated system, which, by the way, our Public Utility Commission looked into and published a report in April. This new deregulated system would mean higher prices for residential consumers, less renewables, fewer protections for consumers, and it could cause critical shortfalls in local, county, and city governments. So let's talk about rates for a minute. Nevada's rates are low. They're currently 17% below the national average. They're 30% below the average deregulated market. For the same time period that Mr. Cherry says that deregulated markets decreased by 14% and monopoly markets increased by 5%, our prices here in Nevada actually dropped by 15%. So that tells you that the Public Utility Commission is really doing a good job looking out for us. If our rates are already the lowest in the region, I don't see how competition is going to make them lower. Competition doesn't inherently lower prices. If you believe that question 3 is going to lower prices, what you really believe is that our price has been set artificially high. I don't see that in the data, and the Public Utility Commission didn't see that either. In fact, they say prices would be higher for at least the first 10 years. Now, could people come in and compete? You know, Mr. Cherry talks about margins from other providers and a 2 to 4% ROI from wholesalers. You know, California, you know, is the wholesale market that they suggest we join, since we don't have one here in Nevada. If you look at they pay twice. If they're only getting a 2 or 4% ROI, they don't have the cost structure to compete with what we have right now. So we'll end it on that, and we'll move on to the next phase here.
Okay. We're going to go on to prepared questions. As in the first debate tonight, the first set of questions were drawn up by the Chamber, Record Courier, Business Council, and the moderator in a collaborative effort. When asked a question, the representative will have 3 minutes to respond as a team to each question, and a two-minute rebuttal may be requested, and then I will tell you that I probably won't grant it. You know, in an appropriate circumstance, I would. But I favor try to make your responses complete. We're going to begin with the no group in alternating back and forth. So either Ms. Long or Mr. Robertson. Several studies, including the Gwynn Commission study, have said they cannot definitively predict how electric rates would be affected by the passage of question 3. Obviously, this is a fundamental difference between the yes and no groups. Would you explain how you see rates being impacted should the question be approved? Go ahead, Mr. Robertson and Ms. Long.
Yes, so we would agree with the Public Utility Commission that we would expect rates to increase at least for that first 10-year period. So a few things are going to drive that. One is going to be the divestiture of stranded assets by the NV Energy and any of our rural co-ops. So as part of implementing this and implementing a competitive market, NV Energy and the rural co-ops are going to have to sell off any of their power generating assets or terminate any of their power purchase contracts. The PUC study says that they would lose $4 billion on that. Keep in mind, NV Energy did a study themselves that showed a loss at around $6 to $7 billion. In the state I was born and raised in, Texas, we were promised a $2 billion windfall, and that turned into a $10 billion loss. So just to make $4 billion a real number for everyone in the room, that's a $25 a month increase to every utility bill for the next 10 years just to pay that cost off. Plus, you're going to have the additional $50 million a year in administrative costs for this new system that are going to get passed to the consumer. We're going to lose $250 million in taxes and franchise fees from NV Energy that are going to have to be replaced. If we are successful in getting companies to sign up for that, that's ultimately going to get passed on to us as well.
Okay, thank you. Mr. Cherry and Mr. Weber. Did you want me to repeat the question? You got it?
Just the instructions on the microphone, that's all. I think I've got the question.
Just talk until they can hear you. Okay, go ahead.
So I'd like to address 2 points there and let you know where we think rates will go. Mr. Cherry already pointed out that rates decline when markets are working. That's fundamental to the American economy, to the success we've had building this country. But to look specifically at what we just heard, divestiture of stranded assets. This is not in the initiative. There is nothing that requires divestiture of NV or any cooperative assets for the initiative to be put in place. NV might have to compete with those assets, and instead of being told how much it gets to make, it gets to make this 10% give or take return on those assets, it might have to actually compete with those assets to try and make them produce a return. So it's simply not true that they have to be divested. Now, if NV decided to divest, and if the legislature decided to let them divest, because it's not their call, it's the legislature's call, keep in mind that if those assets are really $4 billion more expensive than what they're worth, you already pay every penny. Because NV is promised under the current system complete recovery of every cent they've invested. $4 billion, you're on the hook for it today. Every ratepayer's on the hook for it today. Nothing changes under energy choice. It might be moved out of your bundled rate where you just get one rate. It might be a separate line. If, that is, and this is a big if NV were allowed to divest in the first place. It's not in the initiative. That would have to be a legislative choice. Second, taxes and fees. There is nothing about taxes and fees that are paid to local and city governments going away in the Energy Choice Initiative. Taxes and fees that are paid for the right to have those poles and wires on city streets, in county property, taxes and fees that support schools, that support governments, those all can stay in place. You might have to put them in a different place on the electric bill. But that's the point. This is an opportunity to say what is the best, most efficient way to organize our energy economy in the state. And this is the chance for everyone to sit down and do it. Because right now, $354 million in over-earnings, that's not the most efficient way. And if you're wondering if prices can go down, that's evidence right there. Since I think I have a second, I want to just make that point clear. That NV Energy is guaranteed, A, the recovery of every dime it invests in facilities in the state. B, it is then given the right to collect, right now it's 9.4%, has been 9.8%, that allowed return as its reward for doing business in the state. When we say $354 million, that is above and beyond its cost plus 10%. So we're talking about significant over-earnings. There is plenty of room for rates to go down when you use market forces and competition to drive pricing rather than allowing a monopoly to have it.
Okay. Now I'm gonna let you guys in the yes campaign answer this next one first, and then come back to these guys. And I'm gonna modify my canned question a little bit, and the reason I'm thinking about that is because the community where I went to school at in Townhall lost their hospital and haven't had any medical care providers for several years due to market forces. And so I would like you to expand on the same subject about rates and speak to the impact on large users, agricultural users, and residential consumers, and also people who are isolated geographically. How would the market force, a free market that's being advocated, affect people in those segments?
If I can start with a little apology, the number that we have here is 347 million. I have to correct my 352. I got that wrong.
I just put the $5 million in my pocket. Go ahead.
Better than in the investors from out of state who were taking it in. When you look at communities such as Townhall, you mentioned, we already have electric infrastructure connecting those places. That electric infrastructure would continue to be owned and operated in an effective manner by NV Energy or the local cooperative or whoever owns the transmission, just as it is today. Question 3 does not affect that. That's where reliability comes in, because you need to have somebody who you trust maintaining those poles and wires, somebody with the expertise to do that. So you're not going to become disconnected from the electric grid the way when you had, say, telecom, people pull out. Well, you don't have the ability to pull out when you have poles and wires in the ground. And you have a mandate from the state, you have to keep it there, and you're going to be paid to do so. It's important to remember in the electric industry that it doesn't look much different if you're an electric supplier to schedule an electron to go to a place on the end of a line, as opposed to stopping off somewhere on the way. Because electrons go where electrons go. When it comes to deciding rates, it's accounting, right? You generate it, you keep the system stable, you bring it up to the proper level, 60 hertz, and the electrons will flow. So it's not the situation where it's way more expensive to serve somebody in Tonopah as opposed to somebody in Las Vegas, because the infrastructure is already there. And in fact, all ratepayers in the state share the cost of that infrastructure, because everybody contributes to the cost that it took to build that line all the way to that rural community. And everybody in the state continues to pay for the operation and maintenance of that line. So when it comes to reaching communities that are far away, as long as they're already connected, we've seen in some states, such as in Texas, since it was mentioned earlier, there can be situations where it's cheaper because of less congestion on those lines, fewer people using that line. It may actually be cheaper to sell energy to somebody on the end of a line than it is to sell to somebody who's close in. And that's because, again, the cost of that, of all those poles and wires, everybody's sharing those equally. We do now, and would in the future. But the cost to send an electron out there, that's not incrementally larger as it would be with, say, an airline or producing telecom facilities. So we see in other states that have done this, there is not a huge difference. There's availability in rural areas, and reliability is still guaranteed because those poles and wires need to stay where they are. They're already invested in, they're not going anywhere.
And Mr. Robertson, Ms. Long, I'm asking you to expand on how you would see the rates being impacted on large users, agricultural users, and residential consumers, as well as people who are isolated geographically as a consequence of the passage of question 3.
Yeah, certainly. So large users, if you look at that very top tier of industrial electricity user, casino industry, the folks that are backing the Yes campaign, these are the people that do tend to benefit under deregulation. Not only do they have the knowledge and the buying power and the leverage in these negotiations, but currently rates get subsidized to residents through these large industrial users, particularly in rural parts of our state. By the passage of question 3, I think it benefits these folks, but it's doing so at the expense of everyone else. You know, you look at the asset cost and the infrastructure as well. You know, and right now, we do all share in that, except when folks choose to leave, and any of these big casinos have a right to leave right now. What question 3 passing would allow folks to do is leave without having to pay any sort of exit fee to make the rest of the ratepayers whole. So, you know, you can decide for yourself what the motivations are of people back in this campaign, but, you know, I don't think it would be a stretch of the imagination to say that that had something to do with it. Since you mentioned Texas and rates there, one of the things that Texas did in deregulation that was very, very smart, one of the few smart things about deregulation, is they didn't do it as a broad constitutional amendment. It was done through a standard legislative process. So a lot of these rural areas and even, you know, some, you know, local, you know, co-ops or municipal-owned utilities, they weren't forced to divest. They were allowed to remain in the power business and service those customers. So that would not be an option to folks under deregulation in Nevada. And when you see the rural co-ops who've signed on as part of our coalition, that's where those folks are coming from. Look at the Cattlemen's Association and the Farm Bureau, both no on 3. You look at something like irrigation rates, which are heavily subsidized now. That'll go away under question 3. Folks will have to buy that electricity out on an open market. Just like anyone else, and it's going to hurt those folks hard. So I think we're kidding ourselves if we think people are going to line up to sell electricity out in rural areas or even in residential areas. These companies, right now, our power assets are dedicated to serving Nevadans. Under deregulation, people will be able to sell power wherever they get the most money for it, and that's going to be California. If I own a power plant, if I can sell power at twice the price over the border, that's where I'm going to send the power, and folks here are going to get what's left over.
Okay, I have a follow-up question for both sides, and we'll go back to Mr. Weber or Mr. Cherry for the first response. My follow-up question is just so that we can all understand, people that are watching this online or people who are here. I don't understand if we go to a free market system, how the free market would secure the distribution network. And I understand from the responses most of you have given, the production facilities are different from distribution facilities, but both of those are capital assets. And I don't know what the strategy is on this initiative regarding the distribution facilities. And so I'm just asking for a 30-second response, just so that we can understand what would happen to those distribution facilities if under deregulation. First, Mr. Weber or Mr. Cherry.
So nothing will happen to the distribution lines, the transmission lines. The backbone, the infrastructure underneath question 3 will remain the same.
Well, how do they get
changing
paid?
is the generation.
How do they get paid?
So the federal government, right now in your rates, you see one bundled rate. They're not separated. So you have a generation rate and a transmission rate that you pay to NV Energy. It's just one line on your bill. Those will be separated out. So you'll see what you're paying for generation and for transmission usage. The federal government requires that anybody who has a transmission line.
Well, I only gave you 30 seconds. I'm sure Mr. Robertson will clean that one up for you.
Yeah, so NV Energy would become a wires company. Essentially, we're only talking about deregulating the power generation portion. Now, something important to point out about how FERC regulates the transmission, they will set the price that NV Energy is allowed to charge to other providers. They will not set the price that those providers are allowed to charge you. So if this thing passes, if you get somebody knocking on your door and they've got to tell you there's a $50 fee that's a straight pass-through, they're pulling your leg.
Okie doke. I think I'm a little clearer on that now. Actually, no, it sounds like there's relatively consensus on that, and that's what I wanted to know. Okay. Question 3 is approved. Now let's see, okay, you guys are first on this one, Mr. Robertson or Ms. Long. If question 3 is approved by the voters, rates will ultimately be set by the open market instead of the current system of oversight by the Public Utility Commission. What assurances did the residential user have of oversight, and by whom?
There's no assurance of oversight. What this does is, passing question 3, this dismantles everything, and it's up to the legislature to put something back together for us. There's not a plan behind what that would look like. So, it's hard to respond to how this is going to, have oversight when we don't know who's going to come here, who's going to generate power, how are we going to buy power, who's going to, police that from a consumer abuse standpoint. It's one of the more concerning things about this is we're passing a constitutional amendment that hands a blank piece of paper and a blank check to our legislature, tells them to go figure it out, and we may not like what we've got here. And, by doing this as a constitutional amendment, and that has to be in place by July of 2023, even if everybody hates what they get in place, we don't have any choice but to walk that plank. We're not going to be able to put the brakes on it like Governor Nguyen did back in the late 90s.
Okay. Going to Mr. Cherry and Mr. Weber, what assurances does the residential user have of oversight, and by whom?
You'll have the same oversight from the Bureau of Consumer Protection underneath the Attorney General's office. You'll also have oversight by the PUC for the distribution lines in the state. You'll also have oversight from a licensing body that is established for the retail electric providers. They're going to have a license to operate in the state. There are federal guidelines that require what they have to do in terms of providing you with reliable power from a generating perspective. We'll follow those rules. We're going to have an entity or an agency in place to put those rules in place, and we'll do it. It's got to be, and we advocate from the Yes on 3 side that there are black and white rules, that if you are licensed here, you know what you can and can't do, and bad actors have the appropriate consequences if they act poorly in the marketplace. In terms of other guidance for keeping your rates low, it's free market principles. If you go and look at what we've done in competitive markets across the board, you'll see that rates have been driven down by competition as you transition from a monopoly to a competitive market. I just will respond to something that was said earlier where NV Energy's rates went down over that period of time by 15%. What they're not telling you, since 2000, a longer period of time, NV Energy's rates have increased by 50% on you. So 15% reduction over a 8-year period doesn't get you back to where you were when we went through the question of restructuring the markets in the first place.
Okay, now this next question begins with the proponents. How do you feel the results of the vote would impact the development of clean energy from rooftop solar to solar, wind, and geothermal utility scale operations?
So this is another area where there's commercials out there that are saying it's going to destroy everything and it's all going to stop. It's just misinformation, and it's not based on any real facts. Question 3 is specifically designed to create a marketplace where the best resources can be developed and the lowest cost can be provided. Guess what the lowest cost resource is right now? It's solar, it's renewables. So what we see right now is NV Energy has said, you know what, if question 3 fails, if you defeat question 3 for us, let us keep our monopoly, then we'll go ahead and build some cheap solar, 1,000 megawatts. You already have, I think it's 1,600 megawatts of inexpensive solar that is under development right now by private companies who want to develop inexpensive resources. So that shows you the market works. Now, who are they doing it for? They're doing it for large businesses. They're leaving NV Energy's service territory. The same businesses that said, you know what, we left, and not service territory, leaving the electric service. Those businesses said, you know what, we're leaving, paying a big fee. We're still making money because the power is so much cheaper on the market. We want to support question 3 so that everybody has that opportunity. Switch, for example, saved $2 million in its first month, and it's recouping its payment of $23 million so fast, you can believe it. In terms of rooftop, question 3 says that nothing herein will invalidate the principles that the state already has for resources like rooftop solar. NV Energy, who's spent over $60 million already to defeat question 3, already killed the rooftop solar industry once. The people fought back, it's been restored. Question 3 says, you know what? We have a bill passed that provides a way for rooftop solar. Nothing herein is intended to interfere with the state policies that promote rooftop solar now. Now, will you have to change where the payments go? Maybe. Maybe you don't just buy and sell directly with NV Energy. Perhaps you buy and sell with the energy provider. If they want to do business in the state, they have to take part in the rooftop solar program. But the point is, that program is protected under this constitutional amendment, even if we do have to make sure the rules are changed to make it work correctly. It's important to keep that in mind, that yes, this trusts that our legislature is going to do the hard work to put a better energy policy in place that will lower rates, stop the over-earning, and promote renewables.
Okay, let me interrupt you, Mr. Weather, and I'm going to give you a follow-up, and then I'm going to give them a little extra time to answer it, because this is important. If you trust the legislators to set the right rules, then why in the heck are we going through a constitutional amendment? What are the advantages of going to the people for a constitutional amendment instead of going to the legislature? I have a half a dozen questions from the floor that ask the same question. And so I'm anticipating both sides have arguments. I need to hear what you have to say about that. And then, Mr. Robertson, when you guys get a chance, I'll let you answer the first question and the second question. Go ahead, Mr. Cherry. Give him 2 minutes on this, and then we'll hear 5 minutes from the other side.
Okay, so the reason for a constitutional amendment, why we're going through, is since 2008, NV Energy has spent $32 million to influence the Nevada legislature. That is an astounding amount of money. Those are donations, that's lobbying core. That is what's being spent to influence the process currently. You and I don't have a fair voice in that room. By putting your rights into the Constitution, by saying, hey, we want to have rights to rooftop solar, we want to have rights to enter a competitive market, or we want to have rights to join together and produce energy as a group across rate classes, you have a big stick to go to the legislature and say, hey, we got to get this process. We want to see what we want to flesh these out. You don't have that currently. So that's that. I don't need 2 minutes. That answers.
Okay, all right, Mr. Robertson, 4 minutes instead of 5.
All right, fair enough, fair enough. So on the renewable piece, again, if you look at the endorsements that we've gotten, the Sierra Club, Southwest Energy Efficiency Project, Western Resource Advocates, anyone and everyone that really cares about renewables in our state have come out and taken a no position on that. That also includes Congresswoman Dina Titus, who wrote the initial rooftop solar legislation, not just in Nevada, but in the United States back in the late 90s. And Chris Brooks, the Assemblyman from Las Vegas, who wrote AB 405, our current net metering legislation. And the reason all these folks have come out and opposed this is that we're on a good path right now. If you look, where we're at on net metering, there's a system in place that works for folks. It's a system designed to work with NV Energy. If you take them out of the picture, people are going to be able to choose what customers they serve or don't serve. People can say, I'm not going to serve net metering customers, or if I pay you, you can negotiate and sell your power on an open, competitive market and not at a subsidy that was established by the legislature. Big picture on renewables, we're on path to build 6 new solar projects here, 1,001 megawatts, double our renewables from 20 to 40% by 2023, and close our last coal plant. It's not ultimately where we want to be, but it's a great path to be on, and these projects are coming at no rate increase to customers because this is the most efficient, cheapest gigawatt that NV Energy could add to our system. So in and of itself, if you look at this, a regulated market or a deregulated market doesn't necessarily drive renewables. It's going to be your policy around that, but we're on a good path. If I talk about the constitutional amendment aspect of this, to me, this is a complete non-starter. The Constitution is a place where we define the scope of our government. We put limits on government power. We establish rights for individuals. This thing is way too broadly written. There's way too much conflict within the intent of this itself to ever be a reasonable constitutional amendment. To be fair, if they made it really specific, I would criticize that it's overly specific and ties our legislature's hands. That's why it doesn't belong in our Constitution.
Now, this next one, Mr. Robertson, in this long, you're the first responders. Kind of like the firemen, I guess. How should Nevada Energy's statement that they will divest their production facilities if question 3 is approved impact the voter's choice?
I think the first thing to understand is divestiture, while not explicitly spelled out in the language of the ballot measure, is certainly something that was promoted by advocates of this at the PUC hearing. If you look at other states where they have not, gone out and forced this type of thing, Massachusetts, for example, you see 75% of people staying with their original provider. It's very tough to encourage people to come in and compete in this market. You certainly wouldn't see anybody come here and develop new power resources at the prices that electricity is going for now, at least not to serve us in Nevada.
Can you restate the question for me?
Yeah, I'm going to let Mr. Robertson keep talking too, because I'm not sure if I understood what he just said. Okay. How should Nevada Energy's statement that they will divest their production facilities if question 3 is approved impact the voter's choice? I don't understand. Are they telling us?
I'm telling you, it's not a choice for the power company. This is a mandate. I think we should vote no. Due to that, because it's going to stick us with $4 billion in stranded asset costs, and we don't know who's going to come here and operate these power plants.
So you're saying that you guys, or the power company, invested in these facilities based on a guaranteed rate of return, taking it from Mr. Weber's analysis, and that if they don't have the guaranteed return, then they're going to probably sell them to somebody else. It's the only way to recover their investment. Is that kind of what you're saying?
No, I'm saying that NV Energy and any of the roll costs would be required as a matter of passage of this ballot amendment, that they would have no choice, that they would be forced to sell their assets, and they would be forced to exit any power purchase agreements.
Okay, do you guys agree with that, Mr. Weber?
Not at all. And in the claim that the advocates said that divestiture would have to happen at the PUCN, I can tell you is simply not true, because I was the advocate and I was sitting right there in front of the commissioner and I said, there is no divestiture required. So I can unequivocally say, I said it. I was the advocate and that's what I said. But again, what's important is, why would we want to, if NV Energy has $4 billion in out-of-the-money assets, $4 billion in losers, why do we want them to go build another 1,000 megawatts? Why don't we have the market build it? We'll have people who are not out of the money build these resources. And in fact, we've got 1.6 gigawatts, 1,600 megawatts already under development by companies who are doing so on the basis of market principles. So as I look at it, I say, well, it sounds to me like somebody is holding me hostage. I like renewable energy. They say, you better vote no, or we're going to take away your renewable energy. And by the way, they spent $62 million already convincing you to be afraid. So I wonder what there is really to be afraid of here. Certainly, I don't like being told, you don't need choice, a monopoly would be just fine. And by the way, we're going to take away your renewables unless you vote for us. So it would make me a little bit upset, I think, is the answer to my question. I think it should make voters, frankly, outraged.
All right. I have some more questions from the floor. We're going to take one more question and then we'll have closing remarks. I guess this is for the proponents first. You know, it's typical in political campaigns for people to suggest positive outcomes for their position, but I'm still struggling with the way that the existing infrastructure, not only maintenance but development of it, is secured under this initiative. Because all I'm seeing is that the free market's going to take care of it. And when I hear that, I'm worried about telephones and televisions and power and sewer and things like that. So help me out with that, Mr. Weber.
Sure, and I apologize. It's a complex question. I apologize. We didn't do a better job the first time around. The initiative says the legislature need not provide for any changes to the poles and wires part of the system. So if you look what's been done in every other state that has transitioned to an energy choice paradigm, and by the way, a third of the electricity sold is sold in energy choice states, so the sky doesn't fall. But if you look at how it's done, typically, you would receive a bill either from your energy provider that you chose, or from NV Energy. It can be either way. If you receive the bill from your energy provider, it has a line that says X dollars for your distribution and transmission. In other words, X dollars for your poles and wires. Then you have another line that says X dollars for your energy. Now you pay that bill, you pay it to your provider. The provider then takes the money that was collected for the poles and wires, hands it to NV Energy.
Okay, let me follow up then, and I'll give them a chance to respond. I understand what you're saying, but how are we as residential or small business owners or small government users around here supposed to understand that it's going to be better to have a free wholesale market for the production facilities to serve the large users, such as maybe some of the resorts in Las Vegas or some of the manufacturing facilities here and down there. And yet we're going to still keep the control a monopoly for a distribution facility. So it's better for us to keep the monopoly for the stuff that doesn't make money and turn it over to the free market for the stuff that does. And I know that's a tough question for you, but I have to challenge you with that because that's what the people here are asking.
Sure. I can tell you it works beautifully for NV Energy's sister companies because they have poles and wires, which is in the ground, very low risk, especially in Nevada, low natural disasters. They still earn their guaranteed rate of return on that. And I say for NV Energy's sister companies because they have a lot of sister companies in other states and countries that are under energy choice regimes, and they're doing really, really well. So they earn a rate of return that's still set by the PUC. Still set by the PUC. That piece is still, looks just like it looks right now. The energy component is set by market forces. And this is, again, in 13 states, comprising 30-some% of the energy load in the country. This is how it works. The energy piece is set by competitive market because unlike those poles and wires, energy is no longer a natural monopoly. Poles and wires are, because we don't want two sets of poles and wires running down the street. But energy is no longer a natural monopoly because federal and state regulations that have been developing since 1978 make it just as easy for somebody who can do it cheaper to schedule that energy over the poles and wires, just as easy as it is for NV Energy to produce that and schedule it over the wires. And that's because we have now open access on the system that we didn't have back when the monopoly system was set up. So if I'm a power producer, I simply schedule that power to my to the person that is my customer, and the existing infrastructure then is used to take it there. I'm so sorry, I didn't see that was up. My apologies.
Okay, Mr. Robertson, do you agree that it's a good idea to retain the, well, you heard what I asked him. I'm wondering if, I don't have it written down. I hope you remember it. I can rephrase it. I'm concerned, I'm still struggling with the poles and wires, the distribution facilities, which don't make money, and keeping those under a controlled environment. Why is it a good idea to turn the wholesale market over, which seems just by the logic of open markets to favor larger users? And will you answer that?
Yeah, and if I may, Judge Perkins, correct one thing there that you said that there's not money made on the transmission and distribution. There is money made on the transmission and distribution.
Well, I'm glad to know that, and I'll accept that concept.
So under the new system, NV Energy would still maintain the lines and wires. They would still get paid to do that. They would get paid at a fixed rate, not a competitive open market rate. That rate would be set. But again, the rate that your electrical provider chooses to pass on to you for those wires would not be set. So say someone in a rural area could be charged a $50 line fee, where someone in Las Vegas could be charged a $10 line fee. It's going to be up to individual businesses how they want to package and bundle this. So I often make the analogy to this type of deregulation with the type of deep bundling that we've seen in healthcare in the medical industry, and it's just a series of markups. So instead of having something vertically integrated and packaged now, together now with one markup, you're going to have multiple markups coming to you.
Okay, now's the time for closing statements. And I think we're going to reverse the order, so the no on 3 team will go first. Go ahead with your closing statement.
So I'll close where we started out the conversation, and there's one really relevant question we need to ask, and it's not whether we think Warren Buffett is a kindly old man or if we like or dislike Sheldon Adelson. We need to ask ourselves if we want to invest $4 billion in a new system to dismantle one of the safest and most reliable systems, cheapest systems in the country, and replace it with what's going to be a virtual unknown. Of the 24 states that have deregulated, only 14 remain deregulated today. That's not an option to go backwards for us. We're talking about doing this through a constitutional amendment. And once these plants get sold, assets are sold off, we never get the toothpaste back in the tube, no matter how bad this thing goes for us. I would urge all of you to study, look into the aspects of deregulation more. I don't think we settled that debate here tonight, but I hope we can settle a debate as far as whether this belongs in our Constitution or not. Like I said earlier, with the requirement to put this structure in place by July 2023, that's an overwhelming burden for our legislature. Typical session, 120 days every other year. They can do around 500 laws. They've already identified over 2,200 laws that would need to be addressed, amended, repealed, and we're going to have to go down this path without knowing what the plan for the future really is. We don't know who's going to come here and generate power, how we will buy our power, what the rules around all of this are going to be. I make the analogy, this is somebody walking into a bank and asking for a loan, and someone says, well, it's an intriguing idea, let me see your business plan. And they say, well, just give me the money right now, we're going to work out all those details later. The same legislature that they're, don't trust to be able to act on all of our behalf, they're going to trust to enact a very, very complicated deregulation scheme here. I think it's extremely risky, and if we were to go down this path, we deserve much more transparency in what this new system would be, and we deserve to not have it ingrained in our Constitution.
Go ahead.
When I listen to what we hear tonight, and Mr. Robles is very good, and, I like the guy a lot, even though we're sitting up here on opposite sides of this issue. But what he's telling you is more or less the same thing that you're hearing on the commercials that you're getting every time your program takes a break. And it's a story about fear. Be afraid, be afraid, be afraid. It's too hard. Something bad could happen. Be afraid. The monopoly is safe. Let it take care of you. That's the message that I'm getting. And I contrast that with what this whole gathering is about. It's inspiring to come to a place, especially if it happens to be your hometown, and see people turning up to listen to debate, to listen to talk about choices, because that's what democracy is about. It's about having choices and exercising the choices, educating yourselves, and here we all are in this room tonight. Choice and open markets, I said before, built our nation. My grandparents homesteaded on Johnson Lane, and they came from back east, and they didn't have a lot of choices. They started in Fallon picking strawberries, and then they ended up out on East Johnson Lane. You all probably know the site. If I describe it to you, by the Baptist Church behind the water tower has been knocked over now for the development of some more subdivision out there. But they came here because Nevada was a place where they had choice and they had opportunity. And, we're up here having this technical conversation about, well, is this going to happen this way? Will the market meet this requirement? And what it's really about is, do we trust that we can take matters into our own hands and make choices, to make better choices? We have a monopoly system that is well over 100 years old in this country. It is falling apart state by state. They have what they call a utility death spiral, where the monopoly keeps raising its rates on the residentials because everybody else building their own generation, or they're going to energy efficiency. There's no load growth because we have new technologies. Technology is changing this industry. I know because I started out there on the home homestead. I'm an attorney. I try not to talk about the constitutional stuff as an attorney. What I specifically do is I work in energy markets for people who are trying to secure supplies of energy. And I can tell you that it was folks in this state, large users, who got together and said, we paid 23 million, 80 million, 60 million to get out from under the monopoly's hold. And we're making money like crazy on it. We're paying back that investment. Why are our employees not having the same benefit? So the idea that this is because somebody wants to, get out of paying simply isn't true, because the folks that fund the campaign already had the opportunity. They paid. We really believe, thank you, we really believe, and that's why we're here, that democracy, that choice, that opportunity that's offered by technology and free markets is something worth building. The initiative doesn't say how we have to do it. All it says is the only way we don't do it is with a monopoly. We can do it any other way. We can amend it over and over again if we need to, but not as a monopoly. Thank you.
Thank you all four of you for coming tonight. Thank you, ladies and gentlemen, for attending, and thanks to the county for letting us use this facility. That concludes the program. Thank you all.
Thank you so much for attending, and this is the final, last goodbye for the 2008 Town Hall debate. I couldn't be more happier than you. On behalf of the Carson Valley Chamber of Commerce, Bill Cherna, myself, Business Council of Douglas County, and the Record Courier, thanks for your participation. Please get out and vote and share the word that you can find this on recordcourier.com, probably in a few days on demand. Thanks, and have a good evening.